Welcome to Context 101. Please subscribe and hit the bell icon for more breaking updates. A federal appeals court has struck down California's ban on open carry in populous counties, declaring it unconstitutional, a seismic shift for the state's gun laws. The Ninth Circuit's decision sets a precedent that could reshape gun laws nationwide, forcing lawmakers everywhere to reconsider the balance between gun rights and public safety. This ruling follows the Supreme Court's Bruin decision, which demands gun laws align with historical tradition, opening the door for open carry where it's been banned for years. As California scrambles to respond, the stage is set for a fierce legal and political battle that could define the future of gun regulation in America. California's tough gun laws are the product of decades of reactive legislation, shaped by a long and often turbulent history. The state's approach to gun control has never been static. Instead, it has evolved in direct response to the shifting social and political landscape, as well as to the tragedies and controversies that have captured public attention. Each new law is a reflection of the times, a reaction to the fears and hopes of Californians seeking safety and order. Often, these laws have been spurred by high-profile events, moments that shocked the public and demanded action from lawmakers. Whether it was a mass shooting, a political protest, or a surge in violent crime, these incidents have repeatedly served as catalysts for new restrictions and reforms. The media coverage and public outcry following such events have made it nearly impossible for legislators to ignore the call for change. One of the most pivotal moments came in 1967, when the Black Panther Party's armed patrols through Oakland neighborhoods and their dramatic appearance at the state capitol sparked national debate. In response, lawmakers passed the Mulford Act, which banned the open carry of loaded firearms in public. This law was not just about public safety, it was also a reaction to the visible assertion of gun rights by a group that challenged the status quo, highlighting the complex intersection of race, politics, and the Second Amendment. Over the years, California continued to tighten its gun laws, often in the wake of tragedy. Waiting periods were introduced to prevent impulsive acts of violence, and background checks became mandatory to keep firearms out of the hands of those deemed dangerous. The state also enacted bans on certain types of firearms, particularly after high-profile mass shootings that left communities reeling and lawmakers searching for solutions. Each new regulation was an attempt to address the latest threat, building a patchwork of rules that made California's gun laws among the strictest in the nation. In 2011, the state took another significant step by banning even the open carry of unloaded firearms in populous counties. This move was a direct response to gun rights activists who staged public demonstrations, openly carrying firearms to make a political point. Lawmakers saw these displays as a challenge to public order and responded with new restrictions, further narrowing the ways in which Californians could legally carry guns in public spaces. For most Californians, this meant that obtaining a concealed carry permit became the only legal avenue for carrying a handgun in public. The permitting process was strict, with local authorities given broad discretion to approve or deny applications. This system was designed to limit the number of people carrying guns in public, reflecting the state's ongoing commitment to gun control. But now, that carefully constructed system faces a dramatic upheaval. The recent ruling by the Ninth Circuit Court of Appeals has thrown decades of incremental gun control into question. With a single decision, the legal landscape has shifted, forcing California to confront a new reality. Lawmakers, law enforcement, and citizens alike must now grapple with what comes next, as the state's long history of gun regulation faces its most significant challenge yet. The Ninth Circuit's majority, in a closely watched and highly consequential decision, relied heavily on the Supreme Court's recent Bruin precedent. The court found that California's long-standing open carry ban was fundamentally incompatible with the Second Amendment's guarantee of the right to bear arms. The majority opinion emphasized that the Supreme Court's guidance in Bruin required courts to look not just at modern policy arguments, but at the historical tradition of firearm regulation in America. According to the Ninth Circuit, California's law failed this test, as it did not align with the nation's historical understanding of the right to carry firearms in public for self-defense. Judge Van Dyke, writing for the majority, argued that the historical record overwhelmingly supports the right of ordinary citizens to carry firearms openly in public. He pointed to centuries of legal tradition, from the founding era through the 19th century, where open carry was not just permitted but often expected as a matter of personal security and civic responsibility. Van Dyke dismissed arguments that modern public safety concerns could override these core constitutional protections, stating that the Constitution's text and history must guide the court's analysis, not shifting policy preferences or contemporary fears. In a separate concurring opinion, Judge Lee took aim at California's complex and often confusing patchwork of gun laws. He described the state's regulations as arbitrary, noting that they create significant barriers for ordinary citizens who wish to exercise their constitutional rights. Lee argued that the state's licensing schemes and restrictions are so burdensome that, for most people, the right to bear arms is effectively out of reach. He called for greater clarity and accessibility, warning that constitutional rights cannot depend on navigating a maze of inconsistent and inaccessible laws. However, not all judges agreed. In a detailed dissent, Judge Smith argued that states should retain significant flexibility to regulate how guns are carried in public, as long as some form of public carry remains available. Smith warned that the majority's approach could undermine states' ability to address local safety concerns and adapt to changing circumstances. He emphasized that the Constitution does not require a one-size-fits-all solution, and that states have historically played a central role in balancing individual rights with public safety. This sharp split among the judges highlights the deep and ongoing judicial divide over how to interpret the Second Amendment in the wake of the Supreme Court's Bruen decision. The case has become a flashpoint in the national debate over gun rights, with judges, lawmakers, and citizens all grappling with what the Constitution truly requires. The Ninth Circuit's ruling sends a clear message: the right to bear arms must be real, practical, and accessible to ordinary people, not just a theoretical promise on paper. The court insisted that constitutional rights cannot be reduced to legal fictions by overly restrictive laws or bureaucratic hurdles. By grounding its decision in both clear historical analysis and a robust reading of constitutional text, the Ninth Circuit has set a new and influential standard for evaluating gun laws. Legal experts say this ruling will shape future debates and court battles over the Second Amendment for years to come. The Supreme Court's Bruen decision in 2022 replaced decades of legal balancing with a strict history and tradition test for gun laws. Now, any law restricting public carry must have a clear historical analog from the 18th or 19th centuries. The Ninth Circuit's ruling is a direct application of this test, finding no historical precedent for California's open carry ban. Bruen has turned courts into historians, leading to a wave of legal challenges against gun regulations nationwide. The California case is a prime example of how one Supreme Court decision can unravel years of state-level gun control. The ruling sparked immediate polarized reactions. Gun rights advocates celebrated it as a long-overdue affirmation of the Second Amendment, while groups like the Firearms Policy Coalition hailed the court's fidelity to Bruen. Governor Newsom and Attorney General Bonta condemned the decision, vowing to fight it and warning of increased risks in public spaces. Gun safety organizations argue the ruling will lead to more guns in everyday life, raising fears of violence and intimidation. Supporters see open carry as a deterrent and a fundamental right. Opponents fear it will escalate conflicts and undermine community safety. The decision has become a flashpoint in America's ongoing cultural and legal battle over guns. If the ruling stands, open carry could soon become common in California's cities and suburbs, forcing businesses and local governments to adapt. Politically, it challenges California's identity as a gun control leader and energizes both gun rights and gun safety movements. The decision sets a precedent for other Western states, and courts nationwide will look to its historical analysis. It accelerates the national polarization over firearms, fueling new legal and legislative battles. Both sides are mobilizing: gun rights groups to expand their gains, gun safety advocates to seek new strategies. The debate over the Second Amendment is now more intense and consequential than ever. Legal scholar Dr. Evelyn Reed, a leading authority on constitutional law, explains that the Ninth Circuit's recent decision is a direct and significant consequence of the Supreme Court's landmark Bruen ruling. According to Dr. Reed, Bruen fundamentally changed the way courts evaluate gun laws, shifting the legal landscape in a way that few anticipated just a few years ago. Instead of focusing on whether a law promotes public safety or addresses modern concerns, courts are now required to look back in time, grounding their decisions in historical precedent. This means that judges must examine laws and practices from the 18th and 19th centuries to determine if today's regulations are consistent with the nation's historical tradition of firearm regulation. Dr. Reed predicts that, moving forward, future court battles over gun laws will increasingly hinge on how history is interpreted. lawyers on both sides will be tasked with uncovering and presenting evidence from centuries past, debating the meaning and relevance of old statutes, and persuading judges that their version of history is the most accurate and applicable. In these cases, expert testimony will become even more crucial, as historians and legal scholars are called to the stand to explain the context and intent behind laws written long before modern firearms existed. Both sides will marshal their own experts, leading to courtroom showdowns over the interpretation of centuries-old legal texts. In response to these judicial shifts, Dr. Reed notes that many states are already considering new strategies. One approach is to expand the definition of sensitive places, locations where guns can be legally banned, such as schools, government buildings, and public transportation. Legislatures are debating how far these restrictions can go without running afoul of the new historical test. However, the limits of this strategy remain uncertain. Courts have yet to clearly define how broadly states can interpret sensitive places, and lawmakers are left navigating a legal gray area. As Dr. Reed points out, this uncertainty is likely to fuel further litigation and debate in the coming years. Dr. Reed believes that, for now, the Ninth Circuit's ruling signals a broader trend toward expanding gun rights across the country. She observes that recent court decisions have consistently favored individual rights over government regulation, reflecting a judicial philosophy that prioritizes the original understanding of the Constitution. Unless the Supreme Court steps in to clarify or narrow the scope of Bruin, this trend is likely to continue. The highest court in the land holds the power to set new boundaries, but until then, lower courts and lawmakers must operate within the framework Bruin established. For the foreseeable future, the central question for any new or existing gun law will be whether it closely resembles regulations that were in place 2 centuries ago. This historical test has become the primary standard, forcing lawmakers and judges alike to become students of history as much as interpreters of the law. The legal pendulum, Dr. Reed concludes, has swung decisively in favor of gun rights, marking a dramatic shift in American law and policy. For lawmakers and courts across the nation, this is the new reality, one where history, not just policy, will determine the future of gun regulation in America. The Ninth Circuit's ruling isn't final. California will likely seek an en banc review, pausing the decision and sending it to a larger panel of judges. The court's liberal majority could overturn the ruling, but if not, the case may head to the Supreme Court. The legal fight could drag on for years, with the status of open carry in California remaining uncertain. The outcome will shape national precedent on public carry and the Second Amendment. Until the Supreme Court weighs in, the law is in limbo. The stakes for gun regulation nationwide couldn't be higher. The Ninth Circuit's decision is a flashpoint in America's culture war over guns, intensifying the clash between individual rights and public safety. Supporters see open carry as essential liberty and self-defense. Opponents fear it will make society more dangerous. The ruling forces a reckoning with how much modern gun laws can be shaped by centuries-old traditions. As legal and political battles continue, communities must grapple with the real-world consequences. This is a pivotal moment for civic engagement and informed debate. The outcome will help define the character of the nation for years to come.